And Mr. Lewis, call your next witness.
State House Dr. Stephen Lenfest.
You want to take a look at 248 and 265?
I think you're right, Postman, in that record then today.
Good. The testimony that you're about to give will be true.
I did.
Please have a seat. Respond to questions from Mr. Lewis and perhaps also Mr. Gill. Mr. Lewis, this is your witness. You may be proceeding.
Thank you, Your Honor. Good afternoon, Dr. Lenfest. How are you?
Fine, how are you?
Doing well. Would you please state your full name and spell it for the court reporter?
Yes, sir. It's Dr. Stephen Lenfest, STEPHENLENFEST.
Dr. Lenfest, how are you currently employed?
I'm a medical examiner at the Southwestern Institute of Forensic Sciences within the Dallas County Medical Examiner's Office.
And how long have you been in that capacity at SWIFT?
I've been a medical examiner there for just over 3 years.
Could you please describe for the jury education, your background and experience?
Yes, sir. I did 4 years of undergraduate college at the University of Florida in Gainesville, Florida. 4 years of medical school at the University of Florida, followed by 4 years of anatomic and clinical pathology residency at Wake Forest Baptist Health in Winston-Salem, North Carolina, followed by a single year of forensic pathology fellowship here at the Dallas County Medical Examiner's Office. After my fellowship year, I stayed on and became a medical examiner at the office. I am board certified in anatomic, clinical, and forensic pathology and have a full license to practice medicine in the state of Texas.
What is forensic pathology?
Forensic pathology is a subspecialty of pathology, which in general is the study of disease. But in forensic pathology, we basically do autopsies and medical legal investigations to determine cause and manner of death, usually in deaths that are sudden and unexpected or non-natural in nature.
So as a medical examiner, you just told the jury that you do perform autopsies, is that correct?
That's correct.
Describe for them what an autopsy is.
In general, an autopsy consists of a full external examination of a deceased person, documenting general characteristics of the external body, and then a full internal examination of all the internal organs of the chest and the abdomen and the brain.
Approximately how many autopsies have you performed in your career?
A little over 1,200.
And you testified in court as an expert witness in the field of forensic pathology?
Yes, sir.
Doctor, let me direct your attention to April 30th, 2017. Did you have the occasion to conduct an autopsy on Jordan Javon Edwards?
Yes, sir.
And based upon the information contained in your report, how old was Jordan at the time of your autopsy?
He was 15 years old.
What was his date of birth?
Date of birth is October 25th, 2001.
Okay. And can you tell the members of the jury his height and weight at that time?
Yes, sir. At the time of autopsy, the body was 146 pounds and the length was 69 inches.
For the record, your autopsy was performed under the case number IFS-17-07795-MB, is that correct?
Yes, sir.
Just kind of explain for the members of the jury how you actually perform the autopsy, the steps that you go through during the autopsy.
Sure. So I'll just describe this case. Basically, the death would be called in and reported to one of our investigators who creates what's called investigative narrative. It basically describes the general characteristics of the situation that led to the death and whatever information they can get, whether it's from law enforcement, next of kin, sometimes it's from the hospital if that's where the person actually died. Then it's assigned a unique case number and a file is created. In the morning when we all arrive to the office, the medical examiners will review the cases that are there for the day, and then we just randomly divide them up. On April 30th, 2017, I got this case, and the narrative indicated that it was a police-involved shooting and was which would be most likely a homicide, death due to harm by another person. In those cases, once we open the sealed body bag, we would take overall photographs, how the body is received, meaning that if there's medical therapy or clothing still on the body, we just have photographs just the way it is as soon as we open the body bag. Then we would remove the clothing, remove the medical therapy, document injuries, pathology, any abnormalities of the body, clean the body, and again, if there are injuries or gunshot wounds or sharp force injuries, then we do x-rays as well, which we did in this case. During the external exam, we noted what appeared to be a gunshot wound in the head, so we did an x-ray of the head. And I documented those injuries and took additional photographs of the injuries. Once the external exam is completed, then we would do what I described as the internal examination, where we do a wide incision on the chest and abdomen, take out all organs of the chest and abdomen, and then remove the brain as well, examining them for injury or pathology.
You had mentioned that during the course of your autopsy, you took some photographs. Is that correct?
Yes, sir.
And that's just to document the condition of the body. Is that right?
That's correct.
Tell the members of the jury, you already alluded to this, but the injuries that you saw on Jordan.
Sure. So when we were doing the external exam, we noted that there appeared to be a small entrance gunshot wound on the right side of the skull, and there was no exit wound. And so when we did the X-ray, we were able to see that there were multiple projectile fragments inside the skull, which we were able to recover during the autopsy. We photographed those as well after the autopsy. That was the only injury that was noted during the autopsy.
Can you describe in more detail the rifle head of the wound?
Sure. So as I mentioned, the entrance wound was on the right side of the scalp towards the back of the skull. Once the bullet entered the skull, it passed through the right side of the brain and then into the left side of the brain. There was marked devastation of the right hemisphere of the brain, just completely disrupted. The brain stem was disrupted, and then part of the left side of this brain as well, with multiple skull fragments in the parts of the brain. And then again, we were able to recover multiple fragments of the bullet, which broke apart after hitting the skull.
Based upon your exam, I'm sorry, good job.
I was going to say that's typical of a rifle wound also. The velocity of the round is so high that the bullet will shear and come apart once it enters the body.
Based upon your examination, could you tell the trajectory of the bullet as it traveled?
Yes, so there was, again, as I mentioned, quite a bit of disruption of the brain itself. So I was able to determine the bullet went from the right to the left, so it was passing from the right back of the skull, and most of it was recovered in the left front and along that path. And then also that it went from the back to the front. But due to the disruption, I couldn't tell if it had any up or down movement. The track wasn't that intact anymore.
Based upon your training, your experience, your observations of the body, is this kind of injury something that someone couldn't survive?
No, in my opinion, this injury would have been immediately incapacitating and fatal.
Show you a few exhibits, Doctor. If you could please describe for the members of the jury what these are. First of all, I'm going to show you what's been admitted for the record. States exhibit number 5.
That's an image of the decedent that we would take after it's been cleaned. We call it a face shot. It's for identification and to associate the decedent with that unique case number.
And again, for the record, this case number is IFS-17-07795. Is that right?
That's correct.
I'm also going to show you what's been marked as states exhibits 251, 252, 253, 254, 255, 256, and 257. We'll take a look at those and see if you recognize what those are.
Yes, so so these are all photographs that I took at the time of autopsy. 2 of them are as the body was received, overall the entire body. 2 are of the gunshot wound itself. 1 is of the x-ray, and 2 are of the fragments of the projectile that were recovered.
All these photographs bear accurate depictions of Jordan's body on April 30, 2017 when you conducted this autopsy.
Yes, they are.
Did you also complete a report, doctor, after you conducted your autopsy?
Yes.
I'm going to show you the marking states as number 258. You can please tell the jury what that is.
This is a copy of my autopsy report with an additional page of just a diagram showing where the gunshot wound was.
Are you the custodian of this report?
Yes, sir.
Did you make it at or near the time of the autopsy?
That's correct.
Is it the course of business for the Swifts to make these records after autopsy?
Yes.
Has it been altered in any way?
Not to my knowledge.
And are you required to accurately report the finding of your autopsy and reports?
Yes.
States Exhibits 5 for all purposes, 251 through 257, as well as 258.
.258, we object because the witness has testified in court. It's cumulative and it's hearsay.
The objection to 258 is overruled and submitted. I'll give you a running objection to 258.
.256 and 257 are duplicates of one another. We object on that ground.
That objection is overruled. 256 and 257 are admitted for all purposes.
And with regard to 5, 251, 252, 253, 254, and 255, we object under Rule 403 and ask you to conduct a Rule 403 balancing test.
The court has reviewed 251, 252, 253, 254, and 255. The court finds they are more probative and prejudicial and relevant, as well as State's Exhibit number 5. All those exhibits are admitted for all purposes. I'll give you a running objection there too, Mr. Gill. You may publish from there.
Thank you, Your Honor. Dr. Lenfest, I'm also going to show you what's been marked as statement number 284 in a minute for record purposes. Do you recognize what 284 is?
Yes, this is the packaging that, or the envelope that would have sealed the projectile fragments in on the day of the autopsy, and it was sealed and initialed by me.
Okay. You testified earlier that during these autopsies you collect physical evidence, and some of that physical evidence in this case were projectile fragments that you collected from the body. Is that correct, of Jordan Edwards?
That's correct.
Specifically the skull?
Right, from within the brain and then the skull.
Once I'm going to offer State's Exhibit number 284, Your Honor, for all purposes. Did you also take photographs of these fragments as well?
I did. Before we seal them, I would photograph it and then seal the envelope, submit it for evidence for if it's going to be tested later on by the lab.
Subsequently, you did submit those to the firearms unit at Swiss?
I would have. I just submitted to evidence registration, and then they would contact the investigating agency, who then determines what testing they would want done. But it's open and has been resealed, so it appears that some testing has been done.
The further objection we have is that this exhibit states 284 contains a lot of hearsay that hasn't been testified to.
Can I see the exhibit, please? Objections overruled. Submitted for all purposes. You may publish.
Thank you.
What other evidence did you collect during the course of your autopsy?
So at the time of autopsy, we did a gunshot residue kit, which is basically stubs on each hand that we would do on any case with gunshot wounds. We retained the clothing that arrived with the decedent. We did a blood standard, which is just a card with 4 spots, preserved DNA evidence. Head hair standard, fingernail clippings from both hands. The hands were in paper bags when it was received. We retained those also. And then where the gunshot wound was on the back of the scalp, we actually shaved the hair around the wound to get a more clear picture of the wound. That hair we retained in case gunshot residue analysis was requested. And then we retained the projectile fragments and jacketing fragments.
Now, as due course in your autopsy, do you also perform a toxicological test?
Yes, sir.
And what is the purpose of that?
In pretty much all cases, we would do toxicology to look for alcohol and most common prescription drugs and illicit drugs.
And did you perform toxicology on Jordan Edwards' body?
Yes, sir. We did a full toxicology, and it was all negative for alcohol and any other medications or drugs.
No drugs, no alcohol in Jordan's system?
No, sir.
You mentioned that you also perform an internal examination. Any results of that examination that would indicate to you that there's some type of serious injury or disease that would cause Jordan not to have a full and healthy life?
No, there was no other natural disease identified.
Doc, I'm going to go ahead and publish photographs that you took for the members of the jury. For members of the jury, these photographs are very graphic, for the record.
Judge, if they're so graphic, why are we projecting them on the overhead? Perhaps they could be handed to the members of the jury, or the prosecutor could stand up in front of the jury box and show the members of the jury without having to display these in front of the entire courtroom.
So let's how you wish to publish them.
I'd like to publish them as we normally do with all other photographs.
The objections done for the record.
Statement number 5. Doctor, what are we looking at here? And you can look to your left if that's easier for you.
So this is the picture of what I described as the face shot. The scene's been cleaned, and it's an image of just the face. At the bottom is the number. You can't quite see it in the projection, but that is there. That's what this picture is. And you can see, as a result of the wound, he did have numerous skull fractures of all the bones of the skull around the brain, and that's why it appears misshapen.
You're referring to this up here?
Yes, sir.
We also see some injuries to the mouth. It appears to the lip, some blood in the mouth. What does that show?
Most of that is probably just from the base of the skull has fractures, and some of the blood drains down through the sinuses. He was attempted to be resuscitated and had an endotracheal tube placed for breathing, so most of that blood is just settling out of the sinuses.
States exhibit number 251. here, Doctor?
So this is the top half of the body in what I described as the as-is photograph. So this is how the body was received, the condition it was in when we opened the body bag. You can see it still has the medical therapy on the body, and a little bit lower down, the hands are bagged and the feet are bagged in the next photograph.
Now we can see the photograph. Can you describe from your examination of the body, what was the condition of the body as you received it?
And this was the condition.
You see also kind of towards the bottom of the section, number 251, the hands are bagged. What's the purpose of that?
The decedent had been to the hospital, and in any case that's suspected to be a homicide or a suicide, we would request that they bag the hands in paper bags to preserve any evidence that may be on the hands.
And did you take some sample stubs from the back of Jordan's hands to submit later on for further testing?
Yes, sir, we did.
Specifically, gunshot residue, is that one of the tests that's done afterward?
Yes, that's what it was for.
State exhibit number 252. Where is that showing?
So this is again the as-is photograph, just of the lower half of the body. You can see basically from the waist down to the feet. The feet are also bagged. Those bags aren't typically retained. There's not much evidence to be obtained from the feet, and there wasn't any in this case. And the two paper bags accompanying the body had his clothing in it.
State exhibit number 253. What do we see in this photograph, Doctor?
So this photograph is after the body has been cleaned up, and we noted that there's a gunshot wound of the back right side of the skull. And so this is an image of it prior to the hair being shaved.
And for the members of the jury, we're talking about the gunshot wound here,
That's correct.
and that's on the right side towards the back of the head. Is that correct?
Yes, sir, that's the right ear you can see there.
State exhibit number 254. What are we seeing here?
So this is the gunshot wound with the hair shaved, and you can actually see much more detail of the injury itself, which is why we would do that not only for potential gunshot residue analysis later on, but you can see the characteristics of the abrasion around the wound, which is characteristic of an entrance wound. As the bullet passes through the skin, it actually abrades, kind of rubs off that top layer of skin as it's going into through the skin, and so it's completely consistent with an entrance wound.
You indicate that this projectile exited?
There was no exit wound identified, and then when we did the x-ray, confirmed that the projectiles were still inside.
State exhibit number 255. What do we see here?
So this is an image of the x-ray that we performed of the head, and as I described, with a high velocity rifle round, especially with it passing through a thick bone like the skull, the round basically disintegrates, and so there's all of the bright colored pieces are fragments of projectile. The largest pieces being this one here and this one. And they magnify on the x-ray, so you see a great deal of them. Most of those are right here for me to be able to recover them. So we recovered as many as we were capable of recovering. And some of them included the base of the jacket, which is what you can use for, it has marks on it from the firearm itself if you were trying to match the fragments to a firearm.
State exhibit number 256. What do we see here?
So this is a photograph I took of the fragments we were able to recover with the envelope that they would ultimately be sealed within. The piece in the middle that's round, this is the base actually of the itself, of the casing, jacketing of the projectile.
Doctor, it's hard for her to hear you. You can point to that screen right next to you.
Oh, well, okay, sorry. So this is the base of the jacketing of the projectile, and then the gray metal fragments are actually the fragments of the bullet itself.
So for the members of the jury and for the record, the photograph that we see of the envelope as well as the fragments, that's what's here in court today as State Exhibit number 284, is that correct?
Yes.
And finally, State Exhibit number 257. What is that?
This is just a closer image of the fragments themselves. I like to take to, on that first image, I think you see more of the envelope than the actual projectile, and so I usually take a closer image as well.
Thank you, Your Honor. Dr. Lenfest, have you had the opportunity to review any of the video evidence in this case?
I saw one body cam video related to this case.
Okay, do you recall what body cam it was? Do you recall whether or not it was Officer Gross, Officer Oliver, the defendant?
I believe it was not the defendants, it was the other officer that was on scene.
And based upon that video evidence, is it your understanding as well as the history that the victim in this case, Jordan Edwards, was the front passenger of the vehicle when he was shot and killed?
That's the information that I had from the investigative narrative, yes.
Is it also your understanding that the defendant was standing on the passenger side of his vehicle when he shot into the vehicle?
Yes, sir.
Is the gunshot wound to the back right of the head consistent with the victim, Jordan Edwards, turning his head to try to avoid being shot by the defendant?
It's possible. I think it's most consistent just with the idea that he's in the right front passenger seat with someone firing from the passenger side of the vehicle, so you get this entrance on the back right side of the skull.
You also noted in your autopsy report with regard to the range of fire that there was no soot or stippling on the skin. What's the significance of that?
So there are a few ways that we can tell range of fire, but it all depends on what we refer to as soot and stippling being byproducts of combustion of the projectile itself exiting the gun. So either gunpowder is what the soot is, and the stippling is unburnt gunpowder striking the skin. Not all the gunpowder combusts when the primer goes off. Typically you can see that if there's nothing between the skin and the firearm, whether it be clothing, hair, a car window, a door, anything like that. Any intermediary target could prevent that from striking the skin. In this case, what we would say, I would rule this range as indeterminate. There's nothing on the skin that indicates to me range of fire, so I can't make a determination to the range.
And could that be based upon information that there was, again, the victim was in the passenger seat of the vehicle and there was a window, a car window between the victim and the firearm? Would that cause, would that affect the manner in which any gunpowder or stippling, anything of that nature, would collect on the victim?
Yes, it would. Again, if there's anything between the end of the firearm and the decedent that could interrupt that travel of the soot or the stippling, you might not see anything. Like in a case like this, given the information I had at the time of the autopsy, I'd be more concerned if I saw soot and stippling. I'd be like, well, that's not really consistent with someone being in a vehicle or somebody being outside the vehicle.
And finally, with regard to what you just testified about on the autopsy of Jordan Javon Edwards, is that based upon your personal observations and your examination of the body that day?
Yes, sir.
All right, thank you. A couple quick questions, Dr. Lenfest. What, ultimately, with regard to your conclusions, what was the cause and manner of death?
So the cause in this case was ruled to be a rifle wound to the head, and the manner of death was ruled a homicide.
Thank you. I'll pass the witness, Your Honor.
Cross-examination.
And doctor, according to the Texas Code of Criminal Procedure, what are the manners of death which a medical examiner's office can pronounce after an inquest and autopsy?
So the manner of death consists of 5 possibilities, which are natural, accident, homicide, suicide, and undetermined.
And what is the definition of homicide?
So homicide for us in the forensic pathology world basically is a death that is caused by another person due to a volitional act or a voluntary act performed by another person. Intent does not matter, it's not indicative, it's not indicated, and it's not required for a death to be homicidal.
So the term homicide is not coextensive with the word murder, is that correct?
That's correct. Murder is a legal term that we all use.
And homicide is a medical term.
That's correct.
In some of the photographs we saw a few minutes ago, and you described this verbally during your presentation, that the hands and the feet of Jordan Edwards were bagged by the hospital before they got to your office. Is that right?
Yes.
And that's standard procedure to preserve any evidence that might exist on the hands and the feet.
That's correct.
And that's to preserve any evidence that might also be in the form of gunshot primer residue. Is that right?
Yes, sir.
And at the conclusion of the autopsy in this case, did you retain the bags that covered Jordan Edwards' hands and feet as the body was presented to you for autopsy?
So we retained the bags from the hands, but I did not retain the bags from the feet.
You also testified that Mr. Edwards was 69 inches tall.
So I said that he was 69 inches in length, and the reason I make that distinction is for us, height is measured as someone is standing, and for us, it is seen laid on a table, and we're just measuring length and the condition that they are in.
And if you were to convert 69 inches over to feet and inches, what would that be?
It should be 5 feet 9 inches tall.
We'll pass the witness.
Mr. Lewis?
No further questions of this witness, Your Honor. However, the state would reoffer State's Exhibits 246, which is the gunshot residue report by Dr. Castro, as well as State's Exhibit number 248, firearms report by Ms. Francis. They were conditionally admitted until we heard from Dr. Lenfest. We would reoffer those exhibits for all purposes at this time.
Do we have the same objections, Judge?
Those objections are overruled. 246 and 248 are now admitted for all purposes. You may publish, may dismiss, and finally excuse.
No objection from the State, Your Honor.
No objection.
Thank you, Dr. Cleveland.
Thank you.
Dr. Stephan, right now. You can have a seat, Mr. Lewis.
Thank you.
Mr. Sutton?
There's a matter that we need to take up outside the presence of the jury.
Yes, sir. Thank you. Members of the jury, we're going to recess for the day. You would please be back. Actually, Sheriff, don't leave with them just yet, okay? Y'all would go back and wait for the instructions. All right, for the jury. Same instructions, no research. Talk to you briefly in just a minute. Thank you, Sheriff. Y'all may be seated. Mr. Hines, I wanted to make sure I didn't misunderstand. I think that one of y'all represented to me that after the medical examiner, you were more or less complete with your case and sheets subject to certain rulings as seen in the sheets under 404B. Is that right?
Yes, sir.
Okay. So what I intend to do then is to hear arguments on that in here in just a minute, but I am going to release the jurors for today. What I would like to know from the colleagues is whether or not there's any reason why we shouldn't start right at 9 o'clock tomorrow morning. I guess I'm failing my ruling.
From the state, no, sir.
Okay. All right. Why don't y'all give me 1 minute? Voice and recess very briefly. Thank you, Sheriff. Y'all may be seated. Mr. Hines.
Yes, sir.
I wanted to make sure I didn't misunderstand. I think that one of y'all represented to me that after the medical examiner, you were more or less complete with your case in chief, subject to certain rulings as seen as Yates under 404B. Is that right?
Yes, sir.
Okay. So what I intend to do then is to hear arguments on that in here in just a minute, but I am going to release the jurors for today. What I would like to know from the colleagues is whether or not there's any reason why we shouldn't start right at 9 o'clock tomorrow like normal. I guess I'm federal my ruling.
From the state, no, sir.
Okay. All right. Why don't y'all give me 1 minute? Force the recess very briefly.
Do I have all the exhibits? Do I have 246 and 58?
248 is here, 247, 264, 246.
We still got
Dr. Castro's.
All the purposes, I just have.
those two witnesses on standby.
All right, we're going to...
Well, they went off and they just went right off right during that deal.
Y'all will be seated. The court's going to come to order.
I'm going to take my best.
Go ahead. All right, we're outside the presence of the jurors, and all the lawyers are present. Mr. Oliver's present. Mr. Snipes and Ms. Yates. And I believe you have an offer that you wish to make.
Yes, Your Honor. The state would re-urge its 404B motion for the addition of the Arredondo Cuevas assault. We filed that motion prior to trial. It's been discussed once in pre-trial last week, and another time during trial. We would re-urge that motion now, Your Honor.
Do you have, the last time that we discussed this, I had asked whether or not you had any cases. I have two questions for you. First of all, number one is, I believe you offered the evidence pursuant to motive, intent, opportunity, plan, that sort of laundry list under 404.
Yes, Your Honor.
And I had asked whether, and also to rebut a defensive theory. So my first question to you is have you found any cases that are the same or similar to this that would support your position regarding the laundry list in 404B?
With regards to a defense of the third person, Your Honor,
Yes.
I have two examples.
Okay.
Not as to necessarily similarity of facts. I had understood your first question, Your Honor, to be about whether there's a distinction between the body of law on self-defense versus defense of the third person. I have two cases where the 404B analysis was done in relation to defense of the third person. These are just examples, Your Honor, that I pulled, not necessarily for the factual similarity. So, the Tibbs case, Your Honor, is a published case out of Houston. It involved a murder and an act of assault. And the 404B evidence was evidence of gang membership. And the court made its decision based on rebutting the defensive theory of defense of third person. The Salazar case is an unpublished case, Your Honor, out of Austin from 1997. It's a murder arising out of a street fight. The defensive issue was defense of the third person, and the 404B evidence came under that analysis. The 404B evidence in this case was actually evidence of flight. The court determined that the flight evidence undermined the strength of the defense and went to the state of the mind of the defendant.
All right. What about, I'm sorry, you're asking the court to admit this evidence to rebut a defensive theory. What defensive theory is it specifically that you're asking this court to rule on?
So, Your Honor, the state's position is that it does not matter here today in this argument whether defense counsel says that they're adopting defense of the third person, whether they want that in the charge or not. This court's decision does not depend on that. They put forth a number of theories of the case, defensive theories, doesn't have to be statutory. I think primarily those theories are based on protecting Officer Gross. They use the words protect, reasonable, that Officer Oliver was his backup. I think another theory is that he was following Officer Gross's cues. They've emphasized this on multiple witnesses, Your Honor, that he watched Officer Gross remove his gun from the holster, that he listened and he heard Officer Gross's voice changes, and that these things go to reasonable behavior, his reasonable actions, goes to fear and apprehension, it goes to evaluating the potential danger that might be ahead related to a vehicle. So I think that those theories of the case, I think it's clear throughout the case law that it doesn't have to be necessarily a statutory defense.
I agree with you.
Okay.
I agree with you on that.
And those are the primary defensive theories. The state's position is that these two incidents are very similar. Nearly that the defendant's behavior was a carbon copy from one incident to the other. Both incidents involve deadly force. Both involve approaching a vehicle. Both involve assessing a threat that might be ahead related to a vehicle, if any. Both go to his state of mind and the actions that he elected to take. Both involve explanations that he gave later. In the Arredondo incident, he gave multiple explanations. Both are involving fear of a car that might cause injury to himself or a person nearby. And the state's position is that the explanations that were given in both of these cases are false, and that the jury should be allowed to hear the earlier incident, compare it, consider that when determining his state of mind, intent, motive, and knowledge. Your Honor, they've said several times that no one knows what was happening in his head, and this evidence goes to that. Intent is proven through circumstantial evidence. We think this evidence is important to the state's case because they have put forth that no one can know what he was thinking. And the comparison between these two incidents, we believe, shows what he was thinking.
Thank you, Ms. Smith.
That's all I have at this point, Your Honor.
Mr. Gill.
Yes, Your Honor.
Any reply?
Well, Judge, our overall response to all of this is complete proffer. And the complete proffer under any theory they wish to offer it under is this. They offered the evidence they're now seeking to rebut. They offered a video recording, a segment of video in this case, that contained audio. And on that audio contained the audio of this event, including gunshots, including glass break, and including what Roy Oliver said during the event. They offered that. Every case that they cite in their brief, and every case I have come across dealing with 404B evidence and its possible admissibility, says that it's admissible only to rebut a defensive theory. And in this case, the defensive theory, if there is one here, was admitted by the state of Texas. So what they're seeking to do is offer evidence and then offer evidence to rebut their own evidence. So any testimony that we brought out, we had to bring out to explain their evidence. They brought the evidence out. Under Rogers versus State, we had to explain it. We have our side of the evidence here also. But we did not advance a defensive theory. They advanced it. And they can't use that to then rebut their own theory. So we have that objection on that level. And if the court finds that there is a reason for the admission of this evidence beyond character conformity, which is what they're seeking to offer it for, they're seeking to offer it as rebuttal of their own evidence and in character conformity. If the court finds that there is, if they're able to rebut their own evidence, I have other things to say about character conformity, and if you rule that it has a purpose apart from character conformity, I have more to say about that. And overall, at the end of all this proffer, if the court is going to admit any of this evidence, I will also have a 403 objection. I don't think I need to go into any of those further objections right now, because the objection that they're seeking to impeach their own evidence, to rebut their own evidence, is paramount to this entire inquiry.
You said Rogers versus the state?
Yes, sir.
Can you give me the citation on that?
853 Southwest 2nd, 29.
Judge, I just emailed you a copy of it. It's in your inbox. Roger.
Thank you. All right, and Mr. Gill, if you would indulge the court, you said you had additional objections. Should I believe that you raised through cross-examination or something else? An issue that I feel like would be rebuttable. You had 403 objections. I'd like to hear those now.
Well, before I can respond, I need to know exactly what theory they're offering this as something apart from character control. I mean, their brief contains 5 separate, what they claim are 5 separate grounds for the admission of this evidence, and I have something to say about all 5 of those. And if the court overrules me on those, then I do have a 403 objection. I have a number of problems on the 403 objection also.
I'm just asking to hear what your objections would be under 403 too.
Well, my objection under 403 is that the evidence that they seek to admit here is its probative value is substantially outweighed by prejudicial effect. It would be burdensome to this jury to have to hear all the evidence. It takes an inordinate amount of time for the state to be able to present this to a jury. It's cumulative. It's needless presentation of cumulative evidence. It's misleading to the jury, which is a separate objection from the fact that its probative value is substantially outweighed by prejudicial effect. And it confuses the issues in the case. And the issues are confusing enough without having another layer of confusion added on top of those. Those are all part of the 403 balancing test, but I'm objecting under all of those separately.
Yes, sir. Did you have any cases you wish to share with the court under 403?
Casey versus State, 215 Southwest 3rd, 870.
Say 87?
870. Yes, sir.
See everybody tomorrow morning at 8:30. I'll conclude this hearing with that.